In the appeal, the Queen on the application of C and the Secretary of State for Justice.
Lady Hale will explain the judgment of the court.
Publicity, said the philosopher Jeremy Bentham, is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself while trying on trial. The principle of open justice is indeed a precious one. It is there to reassure the public and the parties that the courts are indeed doing justice according to law. There are two rules. The first is that hearings should generally be held in courts which are open to the press and the public. In many cases, the safeguards of a public hearing can be secured without the public knowing the names of the people involved. But the second rule is that those names should generally be published. The main reason for this is that stories about particular individuals are more interesting than stories about unidentified people, so that the press is more likely to write about them and the public more likely to read and be informed about them. But there is also a public interest in knowing how cases dealing with particularly notorious criminals are being handled by the courts. This case is about the second of those rules. The issues are, firstly, whether there should be a presumption of anonymity in civil proceedings relating to a patient detained in a mental hospital under the Mental Health Act 1983. And secondly, whether there should be an anonymity order in this particular case. In 1997, the appellant was convicted of the savage murder of his former girlfriend and her partner. He was sentenced to life imprisonment with a minimum period, or tariff, of 11 years. Because of his serious mental health problems, he was transferred to a high-security psychiatric hospital by the Secretary of State. Over the ensuing years, he made enough progress to be transferred to a less secure hospital and to be given escorted leave in the community. In 2012, his responsible clinician asked the Secretary of State to consent to his having unescorted leave in the community, but this was refused. In 2013, a tribunal notified the Secretary of State that the patient was suitable for conditional discharge from hospital, provided that certain conditions were met. The Secretary of State referred the case to the parole board. The responsible clinician asked again for consent to unescorted community leave, believing this to be an essential precursor to discharge, and this was again refused. The patient challenged that decision by judicial review proceedings in the High Court. As is the usual practice, the court at first made an anonymity order. The challenge to the Secretary of State's decision failed, and the High Court judge also refused to continue the anonymity order. The patient's appeal to the Court of Appeal against that refusal also failed. To bring the story up to date, the parole board in fact recommended the patient's release on life license, subject to some stringent conditions, and he was in fact discharged from hospital in October 2015. The Supreme Court unanimously allows the patient's appeal and orders that he should remain anonymous. There should be no presumption of anonymity where mental patients are parties to civil proceedings in court. However, under the civil procedure rules, the court may order that the identity of any party or witness must not be disclosed if it considers non-disclosure necessary in order to protect the interests of that party or witness. The court has to balance the privacy interest of the patient against the press's right to freedom of expression, and indeed the public's right to know. It is relevant that, in tribunal proceedings about the compulsory powers of detention, care and treatment of a patient under the Mental Health Act, the starting point is privacy and anonymity, although the tribunal may order otherwise. This is because the issues involve personal and clinical confidential information about people who are often very vulnerable and may not be able to make an informed decision about what is in their own best interests. The tribunal is there to assess whether the patient is still suffering from mental disorder of the requisite degree and if so, whether his treatment in hospital is necessary for his own health or safety or that of other persons. Decisions on whether a transferred prisoner should be granted community leave involve a similar mixture of clinical and risk factors. They inevitably involve examination of confidential medical information. It is also a factor that if this confidential information about a named individual may be disclosed in legal proceedings, a patient may be less inclined to be open and frank with his doctors, which is an important element in his treatment and also in the assessment of the risk he poses. And he may be deterred from bringing proceedings to achieve his discharge from detention and the compulsory powers of treatment which go with it. So the principal purpose of detention in hospital may be jeopardized if there is a risk of publicity. In some cases, including this one, there may also be a risk to the patient's own health and safety and that of the hospital staff and other patients. So the public's right to know has to be balanced against the potential harm, not only to this patient, but also to all the others whose treatment could be affected by the risk of exposure. In this case, an anonymity order is necessary. Without it, there is a real risk that the progress made during his long years of treatment in hospital will be put in jeopardy and his reintegration in the community, many years after his tariff period has expired, will not succeed.